effective and defensible legal hold plan should contain the following elements: a statement of the complaint, dispute, or investigation that's given rise to the duty to preserve. The notice should provide enough information about the facts of the case that the recipients will be able to determine what information is considered relevant and should be preserved. So include a list of the key individuals or custodians, relevant dates, major events, locations, products at issue, or any other pertinent information you have about the case. And to avoid the destruction of potentially relevant materials, it's best to provide as much detail about the case as possible. Your legal hold plan should be in writing. Oral holds are possible, but they're rarely defensible and difficult to track. So just make sure your legal hold plan is in writing so it can be repeated if necessary and is certainly defensible. Custodians should be provided clear examples of the potential locations of ESI. They may not think about wearable devices, Alexa, or the like. So the notice must clearly set forth all types of data that should be retained, including ESI, hard copy documents, software, hardware, and the like. It is important to list examples of the various data types that fall within each of these categories, such as email servers, mobile devices, CDs, DVDs, flash drives, external hard drives, voicemails, databases, backup tapes, file servers, and so on and so forth. The legal hold must be addressed to specific individuals, and it must be distributed personally, and it must provide clear instructions for how to accomplish and implement the legal hold. The plan needs to reference a point of contact for any questions about compliance with the hold, because there's definitely going to be questions, and there should definitely be someone the recipient can go to have those questions answered. Legal hold should require a confirmation of receipt. If you send it by email, read receipt should be enabled. If delivered personally, subjects to the hold should sign something indicating that they have received the notice or otherwise attest to the fact that they have received the notice. And then the attorneys and company personnel will want to set up interviews with the main recipients of the hold to explain exactly what's required, answer any questions that they may have. Since litigation can often last for years, there should be periodic reminders sent to the hold recipients that everyone is still subject to the litigation hold. And finally, once the litigation is over, recipients of the legal hold should be notified of their release from the hold. If data preservation attempts are ever questioned, companies should have reliable means of tracking legal holds to defend the preservation process.